and finally try to make some takeaway, some concluding remarks. Now, bail we all are aware of. There are certain criteria for grant of bail. Of course, the criteria differ, but general criteria are the severity of offences, likelihood of accused fleeing, potential of tampering, and risk of further committing offences. Generally, there are 3 tests, triple test. Lastly, restated in the well-known case of P. Chidambaram. But then, if you also follow the special laws, there are 2 more tests. There are legal precedents and statutory guidelines. Before I start, allow me 3-4 minutes of this speech of Chief Justice of India, that is on AI, which probably addresses our various concerns.
The next important area which I want to emphasize is the technological advancements which the Phase 3 document envisages. And this will refer to software development, the use of artificial intelligence, blockchain, and digital accessibility. We are conscious of the fact that artificial intelligence has the flip side as well. For instance, we would be very difficult and diffident in allowing artificial intelligence to tell us what sentence to hand down following a conviction in a criminal case. Many courts across the world have experimented with it. I don't think that we as judges would.
Are you able to listen it?
We exercise on sound
Yes,
official
sir.
life.
But
Please.
there is no sound.
In terms of
Yes, sir,
sentencing
but
policy.
audio.
At the same time,
Audio-
artificial intelligence
audio
does
is
not
not
meet
see
with
the
possibilities.
audio or the video, sir. We are only getting your audio, sir.
You are not getting audio?
No, sir.
No, sir, we are not getting the audio.
Oh, I think that it is currently not very much useful. I should skip this video. See, Chief Justice of India, if this video you see, he makes 2 things very clear. He says that AI has to be used, that is very good, and we have to go with it. But then he makes very clear in sentencing, it cannot be allowed because it is an area of complete discretion. He's very clear on that. Now, he further says that AI can be used for reading records like may have 15,000 pages, and those records can be read very well, and the judges have to face various records. Then he also talks about transcription. Transcription, I mean, if arguments are being made, then the transcription is coming on one of the screen of the court. At least in the Supreme Court, it is happening in certain cases, preferably these constitutional bench cases. These transcription of both sides are coming with the help of AI, and then these transcriptions are given to the parties. They make it error free, and the transcription are made available to these people, and then it comes to the public domain. Then translation. He further says that in the area of translation, for the purpose of inclusive growth, for greater involvement of people in India, it is essential that Supreme Court judgments are made available online on various languages. Indeed, it is available in various languages since 1967. We do not know. The Government of India, Ministry of Law and Justice, there is a wing, official language wing. Its task is to translate. They are translating. But as it happens, it is a government body. They are not worried for marketing. They are not worried for access. They are just doing type of maybe a responsibility. So it did not reach its purpose. I am very well aware because that office is in the building of ILI where I serve. But that does not mean they have not done great job. They have certainly done great job because translation is a difficult job. But that has not reached to the common mass. Not even to those law schools which teach in non-English medium. Now the translation is made available with the help of AI software on the ILI website, on the Supreme Court website, and the Chief Justice says that around 34,000 judgments have been translated in Hindi, in Bangla, in Assamia, in Gujarati, in Kannada, in various languages. There is a separate window made for this purpose that is known as vernacular language. I think it's a great achievement in the leadership of current Chief Justice Dr. D.Y. Chandrachud, and AI is doing it. He has also made available eSCR, and his idea is that why should the judgments, official copy of judgments, official judgments be just with SCC or AIR, which are very, very difficult, very, for which you have to pay heavy price. Why should not that be made available free of cost? And therefore now eSCR is available free of cost. He is telling that these all things are with the help of technology. AI is one of the leading technology that is happening in our country. There are certain words that we use: machine learning, algorithm, blockchain, AI. I understand that because this program is being conducted for last maybe few days, I am sure that this concept must have been dealt with by far more better person, more eligible person, and therefore I am skipping what these concepts mean. Now, before I discuss what is Bell algorithm and what is this rule of P6, this topic, when it was offered to me, it reminded me my days of 1990s, and that becomes very relevant for today. 1993 में I was a student in Banaras, and then those days the computers and new economic policy, they were talk of the town. बहुत बातें होती थी कंप्यूटर पे और नई इकोनॉमिक पॉलिसी पे, and we were in the hostel, and political parties, they used to come to our hostel and they used to say that computers are coming, and if the computers will come, we all will be jobless, unemployment will increase, corruption will increase, and education will be only for those who are technically very sound. So therefore it will be only limited to rich and famous. It is a capitalist conspiracy. Bringing computer or working on computer is a capitalist conspiracy, and therefore we should not encourage these type of computers. It is not fit for India. It may be fit for America. It may be fit for USA. It is almost 30-31 years, dear friends. 30-31 years. And I find that the arguments made against this policy of bringing computers seems to be complete wrong. The arguments were farce. They were false. They proved to be wrong because computers did not take away jobs. They might have taken away some job, but they have created many jobs. There may be some cases of corruption, but they have stopped various corruptions. They have made our life easier, and we cannot think a life without computer today. Now we are one of the leading countries so far as technological workforce is concerned. Good number of our engineers are indeed maybe leading in Silicon Valley. So on all aspects, I find that the arguments which were made in 1993 were not well informed argument. वो जो तर्क पुराने समय में किए गए थे 1993 में कि कंप्यूटर आ जाएगा तो आपकी जॉब चली जाएगी, करप्शन हो जाएगा, चीज़ें खराब हो जाएंगी, कैसे चलेगी दुनिया, भारत के लिए केवल है, दुनिया के अन्य देशों के लिए नहीं है। आज हम लोग सब पाते हैं कि वो आर्गूमेंट सही नहीं थे, वो आर्गूमेंट गलत थे। आज जब एआई की बात हो रही है, कई जगह इस तरह के आर्गूमेंट आ रहे हैं। लॉट ऑफ प्लेसेस दीज टाइप ऑफ आर्गूमेंट्स आर कमिंग दैट AI will replace advocates, AI will replace judges, AI may replace public prosecutors, it will increase unemployment. Same type of arguments. I'm not reaching to any conclusion. Maybe this time the arguments are correct, but let us make an informed decision. जो भी निर्णय लें हम सोच समझ कर लें. Just because some hypothesis is created, let us not run after that hypothesis. उसके पीछे ना भागें हम, वो गलती ना करें दोबारा जो हमने 1993 में की है। हो सकता है कि वो आर्गुमेंट अब सही हो सकता है कि इन आर्गुमेंट्स में दम हो, पर जो भी निर्णय लें एक सोच समझ कर अब निर्णय लें हम। ये जो AI is not something which is new. Of course, this all information has suddenly come in last maybe 3-4 years, but the history says that the first time such words were used in 1950s. The relationship of law and technology started in 1950s, indeed even before such relationship started. Relationship with computer, relationship with technology. Indeed 1970-77 Indian Law Institute published articles on computer and law. Face technology, face recognition technology is not something new. Maybe 10 years back I have seen, 15 years back I have seen this technology on laptop of some persons. Of course it was not easily available. So AI is not something new. Of course it has, because of technological revolution, because of cell phone transformation, it has got an added and better significance. Now, how does it work? Very difficult to explain and understand for all of us, but some basics can be understood. A person, a small child, he is taught about what is ABC, then he is taught about A for apple, B for ball, then he is taught about sentences, and this way he keeps on going on, and then subject changes, and then advanced level. So we study laws of Newton in class 10 or maybe prior to class 10, and then in high intermediate the 12, and then in technology BTech or BSc and MSc, and we do PhD on that. So right from learning ABC to doing PhD on physics or in any other subject, the beginning is from ABC. ABC has been sent on our mind, has been placed on our mind, and we were told how to make words and sentences. Similarly, this AI works. AI, information is fed on that, and the informations are given, informations in various forms, and then based on these informations, based on some rules and regulations, we say A for apple, we say that an is used when there is vowel like A, E, I, O, U. These rules are fed in our mind, and therefore we say an apple. It is said that when you say tsunami, that starts from T and T is silent. These are the rules which have been told to us. Similarly, on the AI and the machine learning cases, rules have to be fed. Rules are already given. Rules have to be given. And based on those rules, what is created is called as algorithm. Now, algorithm is nothing. Algorithm is doing something to, in order to do something in an easy manner, make some rules. Take example of, I have a number of answer sheets. So I arrange it on the basis of roll number. I can arrange it on the basis of alphabets, so that it is easier for us to know. So similarly, that is algorithm. Algorithm is a set of rules in context of computers that is fed on us. Now when we talk about this set of rules, it is very difficult to say what type of set of rules will be given to the machine so that it can decide on legal issues. But for our convenience, we can divide it in 6 segments. That if we want AI in the area of law in general and in area of bail in particular, this rule of P6 has to be followed. Rule of P6 means these rules have to be incorporated in the machine, or machine should be taught, machine should be trained that these are the rules that you have to take from public domain. First is the principles. That is principles of criminal jurisprudence for the purpose of bail, and for the principles of constitutional philosophy also, constitutional jurisprudence also, because bails is directly linked to constitutional philosophy, Article 21, Article 22, and the criminal jurisprudence, various provisions of CRPC, various provisions of other special laws. So the principles have to be, and if we want a good system to work, then these all principles should be incorporated. It will be required to incorporate these principles. So let me quote some of these principles from one of the book from ILI, of which I was one of the author. That is, the book was on law of bail. The principles can be that we all know, just to refresh the memory. There are 3 principles initially. The book writes, first, it is duty of the state to protect every citizen and ensure rule of law. This principle is not written because principles are generally not written. Presumption of innocence. Is it written in CRPC? Is it written in IPC? Is it written in Evidence Act? Probably Juvenile Justice Act makes a mention of this. Probably this Rome Statute of 2002 dedicates a chapter on principles. That is good. But currently we don't have a law where there is complete dedication to principles, but that will be required. If we want this system to work, or if the system is working, then these principles we need to fed in. So first principle would be, according to me, is that we need to fed in the machine is that it is duty of the state to protect every citizen and ensure rule of law. पहला सिद्धांत है कि राज्य का एक कर्तव्य है कि हर सिटीजन की वो रक्षा करे और रूल ऑफ लॉ, विधि के शासन की स्थापना करे, फॉर विच द स्टेट हैज टू बी कॉशियस and watch every suspicious conduct. It is responsibility of the state that in order to protect a citizen, it should be alert to suspicious activity. And this first principle deals with not only security but also bail provision. Second, what is second principle? Liberty is not just a democratic essentiality. It is a natural right. We talk about liberty, we talk about freedom. It is not just a democratic right. Indeed, it is not just a simple right which is required in every democracy, but it is a matter of fundamental right, the most important right, the most powerful right anywhere a person can have in this country. So this is liberty, especially Article 21 and Article 19, liberty. So it is a natural right also. And the second principle further says, constitutional recognition and enforcement by Supreme Court gives liberty the status of fundamental right. This natural right, this human right, this democratic right becomes a matter of fundamental right because constitution has recognized it under part 3rd of the constitution. भाग 3 में इसको रिकॉग्नाइज किया है. तो दूसरा सिद्धांत हो गया लिबर्टी का, कि लिबर्टी ऑफ जो इंडिविजुअल है दैट इज ऑल्सो इक्वली सिग्निफिकेंट. और तीसरा सिद्धांत है प्रिजम्पशन ऑफ इनोसेंस. प्रिजम्पशन ऑफ इनोसेंस इज द फर्स्ट कार्डिनल प्रिंसिपल ऑफ क्रिमिनल ज्यूरिस्प्रूडेंस. The machine must know it, that the principle of innocence, presumption of innocence is the first cardinal principle of criminal jurisprudence. So these three principles, ये दो 3 सिद्धांत हैं. पहला कि राज्य की ड्यूटी है हमारी रक्षा करना और सस्पिशियस कंडक्ट को देखना. दूसरा कि लिबर्टी भी इक्वली इंपॉर्टेंट है क्योंकि ये फंडामेंटल राइट है, क्योंकि ये नैसर्गिक या नेचुरल राइट है, क्योंकि ये डेमोक्रेटिक एसेंशियलिटी है, ये लोकतांत्रिक जरूरत है. और तीसरा प्रिजम्पशन ऑफ इनोसेंस. प्रिजम्पशन ऑफ इनोसेंस मीन्स एवरी पर्सन इज इनोसेंट अनलेस प्रूवन गिल्टी बियॉन्ड रीजनेबल डाउट. अंडरलाइन द वर्ड रीजनेबल डाउट. सो एवरी पर्सन इज इनोसेंट. हर व्यक्ति निर्दोष है जब तक कि यह साबित नहीं किया जाता है क्रिमिनल केस में बियॉन्ड रीजनेबल डाउट, संदेह से, युक्तियुक्त संदेह से परे, नॉट संदेह से परे, युक्तियुक्त संदेह से परे कि वह दोषी है. सो एट द सेम टाइम, सो फर्स्ट सेज यू मे बी सस्पिशियस, तो सस्पिशियस एक्टिविटी कैन बी चेक्ड, सो देयरफॉर ए पर्सन कैन बी अरेस्टेड. सेकंड इज लिबर्टी, सो ही शुड बी रिलीज्ड ऑल्सो. थर्ड इज प्रिजम्पशन ऑफ इनोसेंस. इफ ही गोज टू द कोर्ट, then the person is innocent for the court, even if there are very obvious obvious evidences like smoking gun. It is very clear, there are CCTV footage, but for a court the person is still innocent. These 3 principles are, so bail is a blend of these 3 principles. So the machine must know, like every judge must know these principles, and a balance has to be made for which provisions, policy, precedents, practices and professional opinion come in picture. So the machine must know that bail is something which contains 2 R, release and return. That person has to be released, but his return has to be ensured. That's why there has to be various conditions. So these are the first thing. I would just skip further principles. Machine must have these principles. So maybe before this is started with a very serious note, then the principles have to be fed in, and for this the experts would have to be sit and to find what are the various principles, essential principles that have to be, we need to fed in. Of course these principles are available online here and there, but in the machine we need to fed in. This is one. Second is the provision, and provision we all understand it is black and white. The provisions under CRPC, what are the provisions that deal with bail? So 436, 437, 436 capital A, 438, 167, various other provisions, all those provisions that deal with bail, that has to be there. So currently in Bharatiya Nagrik Suraksha Sanhita, it is 479, 480, 481, sorry, 478, that is equivalent to 436, 479. These provisions, I am skipping this part. So these new provisions have to be incorporated, and both provisions will have to be incorporated, be it CRPC or be it Bharatiya Nagrik Suraksha Sanhita. Why? Because both the laws are existing. Of course, Bharatiya Nagrik Suraksha Sanhita is working, but Bharatiya CRPC is not gone, because the old cases will go on the basis of IPC, and appeal cases will go, even if the appeal is made now, all appeal cases will go with the help of CRPC, not with the help of Bharatiya Nagrik Suraksha Sanhita. So both has to be fed in, and the machine must be taught, must be made understand. These are the provisions of CRPC, these are the provisions of This is one of the challenge. Provision. Then the provisions under special laws that have also to be incorporated, because in some cases these provisions, a comparative study has to be made. Take example of Nikesh Tarachand Shah case. The Supreme Court in the leadership of Nariman has made comparison with CRPC provision, with NDPS provision, with PMLA provision. So a comparison has to be made. So in order to make the machine more and more efficient, it is essential that all provisions that deal with bail has to be incorporated. Third point is policy. Policy. Now, one may ask question, what is the difference between policy and principles? It is an obvious question. General common sense question. So friends, principles वे परमानेंट नेचर के होते हैं, यूनिवर्सल होते हैं जनरली. पॉलिसी कीप्स ऑन चेंजिंग. Policy keeps on changing. Sometimes some principles are mentioned. Policies are not mentioned that way. Not mentioned that way in the law, but they are very much relevant in the enforcement. You will remember in the Constitution of India, there is a complete part, that is part 4, that deals with directive principles of the state policy. It is not only written, but it has to be enforced by the state in their governance, though it is not enforceable by the court. So policy like foreign policy, like education policy, like litigation policy. So policy which is used in case of general offences, policy of bail that is used in special offences. So take example, policy of bail is one of the principles of the policy is that bail is the rule and jail is exception. But then in special laws, courts do not agree on this. They say no, this is not the policy. Policy either is reverse or maybe little bit diluted. Moreover, policy is also executive based. So sometimes the government comes up with a zero tolerance policy, and the prosecution officers are directed that no, in these cases you have always to oppose. You have always to oppose, maybe in cases of terrorism, maybe in cases of PMLA, maybe in corruption cases, maybe in cases of POXO. So the government policy may be zero tolerance policy or maybe a different policy. Policy differs from government to government. Then we come to precedents. Precedents are indeed the whole basis of this, because laws are limited. Laws are limited on bail, but precedents are a lot. We have to incorporate all the precedents. We have to. In some cases, ChatGPT is used to get the precedents. I will also try to demonstrate whether we can get cases or not, and I'm sure some of you must have done it also. But then if we want a standard format, all the cases have to be incorporated, because in the time of internet, because the cases are already there, it will not be very difficult to incorporate these cases. And when these cases and laws are incorporated, certainly it may do miracles. It may do miracles, there is no doubt. So when we talk about precedents, what are the precedents? Various precedents on bail. Let me try to find and try to demonstrate a few things. This is the saved copy of ChatGPT. I can go to this ChatGPT copy also. Let me try to go that. I'm not the first person doing it. I'm sure some of you must have done it. So this chat GPT is now, I'm sharing the screen and I'm going to write something. And I'm going to write what are the leading precedents in anticipatory bail cases. I have written the question to ChatGPT. ChatGPT is free of cost. I am not using the paid version. You have to log in. You need not to make a account. You can log in through your maybe Google also. What are the leading precedents in anticipatory bail cases? I have asked this question and see what is the answer coming. Anticipatory bail is a legal provision in Indian law that talks about what is anticipatory bail. Then Gupta Singh Sibia 1980 case it has given, and with that it is also mentioned what is this case all about. It said the Supreme Court laid down these 3-4 things, and then it says Siddarth case of 2010 and gives its 4 point. Then it goes to another case 2009, then another case, and then Sushila Agrawal, that is the latest one on anticipatory bail, which says that there cannot be a time limit. 5 leading precedents are available now. So these are 5 leading precedents that ChatGPT is taking from public sources, but a standard AI, we need to feed all significant judgment. These are being taken because all significant judgments are available on SCI website, sci.gov.in. Now, as we are dealing with bail, we can easily verify whether these are correct or not. And I tried to verify Sushila Agrawal, and I found that the informations are almost correct. So, last year to this year, ChatGPT has improved, and it keeps on improving. Currently 3 version or 4 version is coming. You can see what Sushila Agrawal says. The court held that anticipatory bail does not automatically end when the accused is summoned by the court, and that is the ratio of the case. The protection of anticipatory bail can continue till the end of the trial. So if you are summoned does not mean, if you are an anticipatory bail and you are summoned does not mean the bail is refused, the bail is gone. No, your bail still continues. You need not to take further bail. Your bail, anticipatory bail is there, then the bail has to be, yes.
Sorry to interrupt here.
Yeah.
Sir, whether AI is able to differentiate between the judgments in prevalence and the judgments which have already been overruled?
Yes, that is another question. That is another question. I think you have asked a very good question. See, let us begin with the very small thing. I gave you illustration that there is a small child. He starts learning from ABCD, A for apple, B for ball, and then he starts learning sentences, and then goes to class 1, class 2, class 3, class 4, class 5, and class 9, 10, 7, 8, 9 he starts studying Newton's law of motion, and then intermediate he further learns. That is how ChatGPT also works. It keeps on learning. So while 1 year back, had I given this same question, what are the leading precedents of anticipatory bail, there was all possibility that Sushila Agrawal case may not have been given. But as you are asking a question, whether it can distinguish, we can always see. So, Nikesh Tarachand Shah, I am writing Nikesh Tarachand Shah judgment. We all know Nikesh Tarachand Shah judgment is on section 45 of section 45, and therefore after this judgment came in, the parliament brought a new legislation, and almost it was type of, we cannot say it is overruling, but it was a type of maybe a type of adaptation. So let me ask the question, Nikesh Terachan Shah judgment, whether Nikesh Tarachand Shah judgment is overruled. This is my question. Question can be different also. Let me see what it answers. In Nikesh Tarachand Shah, the Supreme Court struck down certain provisions of this. Then in subsequent development, it says that judgment in the Nikesh Tarachand Shah case was effectively overruled by the legislative amendment to the PMLA. And that is, I think that is correct. It says amended 45(1) of PMLA, reintroduced twin conditions, adapted it. And then it further says the P. Chidambaram judgment upheld the constitutionality of amendment 45(1). So these are two examples, dear friend, which shows that it is taking this from public domain. While in public domain there can be both type of informations are there. If in the public domain there are informations that Nikesh Tarachand Shah is not overruled, it is still existing, there may be a possibility that sometime it can take that one. That depends on how strong the information is. But then it keeps on learning, like the way we learn. So this is why it is known as artificial intelligence. It is trained, it is made clear that okay, these are the developments. You have to keep in mind that is known as algorithm. So in the area of precedent, there can be more development. Now, if we try to see provisions of law. Now, but I will come to that. When I will discuss the issues that are there with how it can be useful to judges and others. So I am just skipping now. I'm just removing this and uploading the same PPT again. Thank you for asking question. So we can find precedents, because when the judges have to do, the teachers also have to do. Sometimes the students come to us, sir, I am doing research work on Kofeposa and I have never read Kofeposa. What will I do? I used to go to Google, now I will go to ChatGPT. But of course, it is just a check mechanism, kindly note. We cannot rely on that. It is a check mechanism. It is a double check mechanism. We have additional one to check, and there are advantages that I will discuss in the slide when I will come to the stakeholders. So precedents, it is easy to upload precedents because precedents are available, unlike the principles or the policy, because principles are in the judicial decisions, they are not written clearly. Policy is also in the judicial decisions and sometimes in the approach of the government, so it is not mentioned. It is better that we mention it. When the 3 laws came in, I always thought, indeed I have proposed that in the CRPC or maybe evidence, there can be a chapter dedicated to principles of criminal jurisprudence, like the way Rome Institute of International Criminal Court has done. So this was a very good opportunity, so that there is some clarity. When I say clarity, I don't mean there is no clarity. I always mean that it could be in black and white. What is presumption of innocence? What is burden of proof? What is beyond reasonable doubt? What is preponderance probability? There could have been illustrations. But then for academicians, this is a task for all of us to research and present a chapter-wise thing, a section-wise thing for these type of principles. After precedent, I come to professional opinion, which I consider P5. Now, professional opinion is what is the opinion of Law Commission of India? Law Commission is a professional body. So, what is its opinion on bail? Whether it has suggested some reform, whether they have been accepted, how do they interpret the meaning of certain thing? Of course, the interpretation finally can be done by the courts. Then what is the opinion of any other professional person who has written a very good book? Maybe Sirvai, maybe in criminal law, criminal jurisprudence, maybe some foreign author has written something, some Indian authors have done something. Their professional opinions, they also matter. They also matter. Now, one question may be asked: why in bail? How could in bail the professional opinion matters? Indeed, how in the decision making professional opinion at all matters? So, to begin with, Supreme Court, it does matter, because based on professional opinion, the courts give new philosophy, new ideas. So, professional opinion does matter. Upendra Bakshi has been quoted many times, and then Glanville William and Glanville Austin, they have been quoted, and Professor Veer has been quoted many times. So those ideas have been incorporated in our country either directly or indirectly, or at least for support. I understand for a trial court judicial officer, probably this will not be of very much significance, But then professional opinion, I do consider it is a part of this law, the group of law that has to be fed in, that has to be incorporated in the machine when we do deal with this machine learning process. Now, what is professional opinion? What is this practices? Practices means law is one thing and practice is different thing. And when we deal with bails, we are aware of what type of practices are there, and therefore we draw certain principles, certain maybe conditions. So practices have to be taken care of. So I'm not further going detail, because practices are something which cannot be written in maybe exclusively. So, but these 6 things may be considered for the purpose of AI. Now, there are 4 stakeholders for the purpose of bail. Indeed, for every purpose, there are 4 stakeholders. For the purpose of bail, also, the first stakeholder are judges, not in the chronology. Indeed, the first stakeholder is the petitioner. But the most powerful person who has the responsibility under law to grant bail or refuse bail, he is a judge. So what can he do with the help of AI? What he does, he analyzes the facts. Facts are given by both the parties. Many times they agree, sometimes they disagree. Therefore, there are facts in issue. Then, in courts, timeline is produced. Sometimes timeline in the Supreme Court, in the High Court, timeline is a part of process. Then they also find precedents, and I have just demonstrated that if you want to get precedents, how ChatGPT may be useful, underlying the world may be useful, and whether precedent is applicable or not. We have also dealt with this, that Nikesh Tarasan Shah, if there is a dispute whether it is applicable or not, some expert has written it is not applicable. ChatGPT can be one of the source to doubly ensure that whether it is applicable or not, and we can say that no, Nikesh Tarasan Shah is probably not applicable. Now, analyzing the fact, for this purpose, let me try to do something that let me try to go into a case. Let me try to find a case and see whether an analysis can be done or not. So, we all know Sushila Agrawal case. Sushila Agrawal case. Is a case on anticipatory bail by a constitution bench. Now I shall try to share the screen of again ChatGPT. And you can see there is a place for attachment. There is a place for attachment. And I will just attach the copy of that judgment, and the copy is uploaded. I think you can see this copy is uploaded. And when the copy is uploaded, I am now going to give its instruction. And what is my instruction? Please or analyze this case under following heads. Introduction, facts in issue, arguments of both parties, decision. Under 5 head I have made. Analyze this case under following heads. This case, suppose I have never read it. I want to know what is this. Arguments of both parties, decisions, and then principle laid down. And I am trying to give this command. So introduces it. I think you can see this is the judgment. This judgment is in various pages. It is in 76 page. This judgment is 76 page. We all know that it needs additional time for all of us to study. So introduces it. The case Sushila Agrawal and others decided by the Supreme Court on this date addresses the critical issue of anticipatory bail under section 438 of this. The case was brought before the Constitution bench. It makes very clear, and I have read, therefore I know that these facts are correct. I am doubly sure. This is the one thing I can do. Doubly sure. Constitution bench. So it is the Constitution bench. So it is the most important judgment. Conflicting views, because earlier there were some conflicting views. What are the facts? Several petitioners, including Sushila Agrawal, sought clarity on the duration of anticipatory bail protection. The case emerged from conflicting judgments by various benches of the Supreme Court regarding the limitations and conditions of anticipatory bail, especially the case questioned whether the protection granted under section 438 CRPC should be limited to a fixed period to enable the person to surrender before trial court and seek regular bail, whether the life of anticipatory bail should end when the accused is summoned by the court, and we know no, it cannot end, it does not end. And so fact in issue is then the both fact in issue given, arguments of both the parties, arguments on the limitation period, arguments on judicial discretion, arguments on precedent, respondent argument, fixed duration, surrender and regular bail, and the decision. So state always argued that yes, once he is summoned, then his anticipatory bail goes on, and therefore he must seek regular bail again. But the Supreme Court declined, and the decision came no fixed duration. Judicial discretion, courts have the discretion to impose conditions and limit the duration of anticipatory bail. No invariable rule. The court reiterated the principle from Gurbakh Singh Sibia, emphasizing that there should not be an invariable rule limiting the duration of anticipatory bail. Then what is the principle of law laid down? The decision reaffirmed the principle this and carried on. So I have also found that in some cases the information are wrong. In some cases. So if the information is wrong, we can further go and verify it at other places. Read another book. But we have now this 76-page judgment. We know this, we read this. Just want to verify ourselves that whether we have understood well or not. What we used to do, we used to go to our friends, go to other website. Now ChatGPT is additional source which is available to all of us. So this is how this can be useful for us. Now, if the learned participants have any query, they can just raise the query so that we can have far more fruitful discussion. Now I will again share the screen. Yes. So analyzing the fact, timeline. So we can find timeline also. I'm not going in that. Finding precedents also, whether precedents are applicable or not. So I will come to discuss on, yes, but I have requested and it is very clear that it is good when you have made up your mind. You have read the case, you have made up your mind. Initially you want to be doubly sure. Use ChatGPT to write orders. Once you are sure that you have made up your mind that okay, इस मामले में तो हमें बेल देनी है, इस मामले में बेल नहीं देनी है, हमने फैक्ट्स रख दिया, हमने डिटेल रख दिया और उनको कहा कि उनको आप पूछ सकते हैं based on this whether you will grant bail or not, or bail should be granted or not. They may write yes or no, but you can also write that please give me an order in favor of grant of bail, and the favor of grant of bail, the order comes. One can read the orders. If he is okay, then after making some changes that the Supreme Court is also doing, that removing the errors after reading, the order can be maybe uploaded. We are using our law clerks in the high courts, in the Supreme Courts. Law clerks often say that in some of the judgment, I was a part of that judgment, sir. I have given this judgment to Fala Supreme Court judge, and I am happy to share that my judgment is now the part of the Supreme Court judgment. It was added as it is. Law clerks can do, and law clerks has done, and after that the Supreme Court judges have become doubly sure that it is okay, it is correct, and they do it. So suppose you have to write.
Sir, in that case,
Yes.
sir, in that case, can the mind of a judge be prejudiced against the AI generated decisions?
That is what I am trying to say. One should not go for the judgment or order before making up your mind. Don't go to ChatGPT to find the judgment. If you want to do research work on precedent, if you want to do research work on laws, if you want to know comparative position, then it is all right. But don't, after giving the facts, don't ask the chat GPT what according to you should be the correct judgment. I would always say, I always discourage, don't do it. Don't get prejudiced. You get all information. Please get all the laws. Please get the precedent, which is applicable, which is not applicable. That's a different matter. But don't prompt, don't say, don't ask chat GPT or other AI that what according to you should be the judgment or what should be the judgment based on these facts. No. First make up your mind that yes, I have to give the bail, and then you go. So it will reduce the chances of prejudice. Reduce the chances of prejudice. I'm not telling that the prejudice won't be there, because suppose you have made up your mind that Arvind Kejriwal should be given granted bail. Suppose yourself, you are a competent person to deal with Arvind Kejriwal case, should be granted bail, and you have placed all the facts, and the chat GPT says no, he cannot be granted bail. It is a PMLA case, it is a corruption case. He is a chief minister, he is a very high position, and president says that no, bail cannot be granted. His colleagues have not been granted. They are part of the same transactions. So now there is a conflict. You have made up your mind that the bail has to be granted. Chat GPT says the bail is not to be granted. What will you do? I won't say you go by your own lining. No. I would say that you go and try to find where there are serious flaws in your reasoning, and serious means some good points, very good point in the chat GPT argument, reasoning. Did you miss something? If you miss something, then you can go by that, go with that. And we all know in Punjab and Haryana High Court and maybe in Manipur High Court, two learned judges have done, and we will try to discuss it. So I think it is a very good question regarding prejudice. So let us not allow the prejudice to come in. It is, dear friend, just as good. Let us use it as good as our assistant, not our boss. It is as good as our assistant. Just remember, 20 years back, we used to go to take physical copy of AIR and then used to search what are the cases. Now on Google, we can search the cases. We are taking assistance of Google. Google is not our master. Computer is not our master. So AI should not be our master. Let us allow, not also allow AI to become our master in any cases, especially in bail cases, because bail cases are different cases. Bail cases means we are dealing with Article 21. We are dealing with right to life and personal liberty of everyone. थोड़ी सी चूक से भी अर्थ का अनर्थ हो सकता है, थोड़ी सी चूक से भी. तो AI has to act as a not as a maybe as a master, but as a servant, as an assistant to us. Now I will just go to one of the judgment where chat GPT is used. And this judgment is in 2-3 pages, only 2-3 pages. This judgment is by Punjab and Haryana High Court, and the name of the case is Jaswinder Singh Jassi versus State of Punjab, and I am sure many of you must have noticed it. It is easily available on, you can just, it is just a 2-3 page. I request that you search it and please find this judgment, Jaswinder Singh Jassi versus State of Punjab. And please, some of you let me know at which place chat GPT has been used. So my question to the learned house is, the learned virtual house is, that please let me know in this judgment what for the chat GPT is used. I am waiting for 1 minute. Kindly search and let me know. Anyone can take the lead. I heard that researchers are also there, faculty members are there, we have cross-border participants also, we have learned judicial officers, learned faculty members also. Anyone can take the lead.
Sir, is it bail?
The name of the case is Jaswinder Singh Jassi versus State of Punjab. It is on bail. It was decided by Punjab and Haryana High Court, dated 27/3/2023 27 मार्च 2023 को ये केस डिसाइड हुआ है, जसविंदर सिंह जस्सी वर्सेस स्टेट ऑफ पंजाब। आपको ये बताना है, ये बेल पे केस है, आपको बताना है कि चैट जीपीटी का यूज़ उन्होंने किस उद्देश्य के लिए किया है। व्हाट फॉर चैट जीपीटी इज यूज। यू कैन यूज योर मोबाइल फोन, इफ यू हैव कंप्यूटर विथ यू कैन यूज योर कंप्यूटर। आई विल वेट फॉर 1 minute.
No, sir, this is to testify whether chat GPT is correct or not.
This was
at para 7 of the judgment.
yes. So what is Mishra Sahab, Chinmay Mishra Sahab is telling, Prabhakar sir is telling it is to verify, it is just to doubly sure, while Chinmay Mishra sir is telling that it is in para 7. Can you just, without reading it, there is no need to read. Anyone else want to say something? Ritesh, yes please, Ritesh ji bata.
Sir, to get a worldwide view on how bails have been awarded worldwide.
Worldwide the bail is awarded, so has he referred to any case from USA, UK or Australia, Canada? Where is the worldwide view?
Sir, for that reason,
I'm not finding any worldwide view in my copy.
No, sir, I need to go through it, sir. I need to go through it.
But it is a small paragraph, very small paragraph. If you have the judgment with you and this judgment is first page is almost very small. Second and third you have to read, and last one is there is nothing almost. Yes, please.
Sir, the judge in the para 10, sir, actually he had placed a question to the chat GPT whether what is the jurisprudence on bail when the assailants are assaulted with cruelty.
Yes. तो इसका मैं माने बताता चलता हूँ थोड़ा सा अपने समझने के लिए भी, कि चैट जीपीटी से जज महोदय ने ये क्वेश्चन किया है कि व्हाट इज द ज्यूरिस्प्रूडेंस ऑन बेल व्हेन द असैलेंट्स असॉल्टेड विद क्रूएल्टी। बहुत स्पेसिफिक क्वेश्चन है, हम तो अभी जनरल क्वेश्चन देख रहे थे, बट ही हैज आस्क्ड द स्पेसिफिक क्वेश्चन। चूंकि ये मैटर क्रूएल्टी पर है, क्रूएल्टी के मामले में जो आक्रमण करने वाले हैं, जो असॉल्ट करने वाले हैं लोग, जिन्होंने किसी दूसरे व्यक्ति के ऊपर क्रूएल्टी की है, वहाँ अगर बेल की डिमांड हो रही है और किसी की डेथ भी हो गई है, जो डेथ की बात इसमें नहीं लिखी है क्वेश्चन में, तो ऐसे मामले में बेल का लॉ ज्यूरिस्प्रूडेंस क्या है। और उसके बाद ये आंसर दिया गया है 2-3 पैराग्राफ में चैट जीपीटी के द्वारा, जिसको उन्होंने इनकॉर्पोरेट किया है, ये देखने के लिए कि उनका जो डिसीजन है डिनाई करने का वो सही डिसीजन है कि नहीं है। सो चैट जीपीटी हैज़ बीन यूज्ड इन दिस केस एट यस। कोई और बात कहना चाहते हैं आप? एनीवन वांट्स टू से समथिंग? So this is how ChatGPT judges can use just to find the jurisprudence. Now, doubly sure, I told you, make up your mind. And if the ChatGPT is giving something new, not just to cook ChatGPT, but something new is coming, then one can secure and save his time. आप सोचिए, आपको एक दिन में 15 जजमेंट लिखने हैं, क्या आप लिख सकते हैं? क्या एक जुडिशियल ऑफिसर 15 जजमेंट लिख सकता है? नहीं लिख सकता है। Now you have made up your mind, A, B, C, 1, 2, 3, 4, 5 में मुझे रिजेक्ट करना है, 6 में देना है, 7 में ये करना है, 8 में। आपने इसको चैट जीपीटी पे डाल दिया, ये नहीं पूछा आपने जब मेड अप योर माइंड कर दिया, देन आपने पूछा उससे कि आप बताइए हाउ द जजमेंट शुड बी, एंड देन सो इन सिंगल डे you can write the judgment, you can place the judgment. This is the advantage. जुडिशियल ऑफिसर का बर्डन इससे कम हो सकता है यदि हम थोड़ा सा इसमें अपने आप को ट्रेन कर लें। सो मैं आपको ये भी बता रहा था, आई जस्ट वांटेड टू शेयर विथ यू व्हाट माय अनदर पीएचडी स्कॉलर अपूर्वा हैज ब्रॉट टू माय नोटिस इज दैट देयर इज अनदर जजमेंट ऑफ मणिपुर हाई कोर्ट, मणिपुर कोर्ट, दैट इज रिट पिटिशन सी नंबर 70 of 2023, जाकिर हुसैन वर्सेज स्टेट ऑफ मणिपुर. Zakir Hussain versus the state of Manipur. And in this case, Manipur High Court has utilized the AI tools, especially ChatGPT, to clarify the structure and roles within the village defense force during a dismissal case. So it is not a bail case, but it is a different type of case. So I'm just skipping this part. Now, I told you what a judge can do. He can find whether the logic and language matches or not. आपसे logic और language match कर रहा है कि नहीं match कर रहा है. And then what in Jaswinder case has been done? Jurisprudence has been brought in. Then if you are convinced, then all right. If you are not convinced, you do your job. But the most important thing, dear friends, that the confidentiality is maintained now. You need not to share this. You need not to ask your junior, your maybe your munsif to write it and then worry whether it will be out before I can do something. This is the fear many judicial officers have shared, and they said, sir, this is why we write our judgment ourselves. Are not you doing the same thing in order to ensure the confidentiality? I think you are doing the same thing. The judicial officers are doing the same thing. In order to ensure confidentiality, घर जाके अकेले में लिखते हैं ताकि ऑफिस के स्टाफ को भी पता ना चले. Now ChatGPT is making it easier. Confidential वो रह जाएगा. तो इवन लॉ कलर्स के लेवल पर हम देते हैं तो कुछ चांसेस होते हैं उसके लीक होने के. और आपको ध्यान होगा यूएस के सुप्रीम कोर्ट का जजमेंट भी लीक हो गया था. यूएस सुप्रीम कोर्ट का जो जजमेंट है वो लीक हो गया था. सो confidentiality is probably one of the best thing. But one question can be asked, that if you are placing something on ChatGPT, is not the data going to the ChatGPT? The answer is yes, the data is going to the ChatGPT. There is no doubt. But they are maintaining this confidentiality, and as per US law or as per the law of the country they belong to, they can disclose such type of confidentiality only if the law permits, in essential cases, not in all cases, in essential cases. So we all know most of the request by the government of India is rejected by the Facebook, rejected by the WhatsApp, rejected by the Twitter, because government of India is not able to present that it is an essential case. So if it is a matter of national security, certainly matter have to be given. Now, can I move to the next part of discussion? That is for advocates. Now, I think the advocates are not going to like it. Many advocates, while many are going to like it, but many are not going to like it because they have some fear that it is the ChatGPT which is probably going to compromise with my job and my money. And there is the apprehension is not almost wrong. Apprehension is to some extent correct. While ChatGPT will help him know various judgments immediately, and if he is a sensible advocate, learned advocate, who believes in the philosophy of the Constitution and not an ambulance chasing lawyer, then certainly he will take the help of ChatGPT to make the process faster and faster. He cannot say, अरे भाई ये तो अभी अपील केस है, ये इतना मोटा जजमेंट है, ये देखो ये 2000 पेज में है जजमेंट और रिकॉर्ड, इसको तो पढ़ने में 2 महीने का टाइम लगेगा. Not required now. Not required. You can find your information. Find many informations पूरे जजमेंट को पढ़ने में. अगर if you have the philosophy inside you, that philosophy of fair trial and fast track trial and speedy trial, then petitioners, how is it going to help the petitioners? Now petitioners, an alert petitioner are going to be helped by many. I have been approached because I am a faculty member, I am a teacher, and my office is in front of the Supreme Court of India. Many times, people who know me and people who do not know me, They approach me, सर बताइए सुप्रीम कोर्ट में अपील करना है, क्या चांस है अपील को एक्सेप्ट होने का या रिजेक्ट होने का. I know this question is very difficult, but we know in SLP cases, especially petition cases. So I and like me, many other people must have been asked, what are the chances if I file an appeal in the Supreme Court? Some people come and they ask, why should I spend, sir, if I think the chances are not good, why should I spend money? I will not spend money. I have gone to the court, learned advocate, and he said, yes, I will try my best. Because an advocate has his profession. He will always take the positive side. Even if it is SLP, even if he knows that 99% of SLP is rejected, he will say, you see, कल एक SLP जो है एक्सेप्ट हुई है, आपकी भी होगी. He will take positive side. He knows that this SLP is not going to be accepted, but he will take the positive side. It is a part of his profession. I am not criticizing the advocate. Just let me give you a small illustration. When I was just leaving my office at around 5:30, it was maybe 3-4 years back, a person who knew me through someone came to me and he wanted a bail in 304B cases. In 304B, his younger brother was inside the jail. He was acquitted by the trial court. The acquittal was turned down by the High Court, and therefore the father and the mother and the husband all were inside jail because the bride, she died because of suicide. So came here for bail. I told that chances of getting bail according to my experience is not good. Then he said, sir, I met Fala advocate. He said 304B के केस में कल ही तो बेल कराया हूं, कल ही बेल कराया हूं. I told that, see, your case has just come to the Supreme Court. It will take some time, at least 2-3 months. The petitioner informed me, sir, advocate ने कहा कि 2 दिन में बेल हो जाएगी, बस एक बार वहां लगना चाहिए. I told him, the learned advocate has just told you, of course bail can be granted, पर भैया 2 दिन में बेल तो नहीं होगी, ध्यान रखना. Now the petitioners have chances that with the help of ChatGPT he can get. What are the chances of getting bail? An alert petitioner in Supreme Court, every person does not come. I have met many people who are not from law background. Even if law background people cannot be sure whether the petition can be accepted or rejected. But then he can take the help that based on these facts, whether bail can be granted or not. So the chances, and everyone agrees, many people agree that drop in appeal cases would be there. There will be drop in quick petition. तुरंत डाल दिया, तुरंत petition डाल दिया, that will be. Then there is another point. Then one person came to me that, sir, one of my friend's child is in POCSO. An FIR is registered and there are chances that he will be arrested. And I want to file an anticipatory bail plea. So is anticipatory bail applicable or not? I told, yes, in POCSO, anticipatory bail can be granted. Then he also told that, sir, this case is also registered under SC/ST Act. Then I told that in SC/ST there is no provision for anticipatory bail. Section 18 was there, Section 18A was incorporated. The Supreme Court said in Santosh Kasinath Mahajan that bail can be granted. The Parliament came in and they said no, it cannot be granted. So if the case is also on SC/ST Act, the bail cannot be granted. So these people, while the advocate has filed the case, and advocate should file the case. I don't criticize, because a new law can be evolved. The way Santosh Kasinath Mahajan, Dr. Kasinath Mahajan case came in, similarly new law can come in. And it can be said that in anticipatory bail, Even if there is a complete prohibition of anticipatory bail can be granted in certain cases. And the law is currently like this. The court can decide case to case. So let me again go that can it help us? Can it help us? ChatGPT, can it help us?
So then again the question of probability will come, that what is the probability of that chance when the petitioner is asking a question to ChatGPT, and whether he can completely rely upon the same.
I don't think he can rely on that. But he can be sure, maybe if I am telling that chances of getting bail in next 2 months is not there, maybe some advocate has said, another advocate says that no, I will do it, I have done it, in order to grab more and more cases, then he will be in a position to understand that okay, ChatGPT is also suggesting that there is no chance of bail. But before that, let me write a question. Suppose a person is not aware of whether in SC/ST case anticipatory bail can be granted or not, and the learned advocate says that I will do it. He does not inform that anticipatory bail it is completely prohibited. So I am considering myself an unknown who is not aware of law and writing a question to ChatGPT. Can anticipatory bail be granted in SC/ST cases? I have not even written the law. SC/ST Act I have not written. Can anticipatory bail be granted in SC/ST cases? Because I have told this person that it cannot be granted, but advocate says that yes, I will try, I will do it, don't worry, I have done it. Let us see what answer ChatGPT gives. Anticipatory bail in cases under SC/ST, this is contentious issue. The law has evolved through several judicial decisions. The reflecting this balance background, SC/ST Act was enacted in this scheduled offence explicitly bars the grant of anticipatory bail. A person who is not in the field of law, he may be an engineer, he may be a doctor, he may be a businessman, he is not aware of, he knows only अभी एंटीसिपेटरी बेल क्यों नहीं मिलेगा, आर्टिकल 20 है हमारे पास, 21 तो है ही हमारे पास, उसको ये नहीं पता है कि there are certain laws that anticipatory bail has been barred. Go to ChatGPT says Section 18 of the Act explicitly bars grant of anticipatory bail to individuals accused of offences under this Act. Then he finds 2 cases. So he is in a position to take a further more informed decision. Then see the third point. For our convenience, I am making it like this. The ChatGPT says, AI says, the SC/ST Prevention this Amendment Act, in response to Subhash Kasinath Mahajan's judgment, Parliament amended the law, reinstating the provision that judgment has diluted, including the bar on anticipatory bail in 18A. Then the Prithviraj Chauhan has upheld it. The Supreme Court upheld the 18th Amendment, including Section 18A, which reaffirms the ban on anticipatory bail. So, a person sitting in Guwahati, sitting in Madras, trying to come to Delhi, a person sitting in Basti, trying to go to Allahabad for taking an anticipatory bail because it has been rejected, and the learned lawyer thinks that he may convince a new law can evolve, says that yes, I will try my best. Why not another Subhash Kasinath Mahajan case? It is Article 21. I will argue on the line of Article 21. So a petitioner is in a better position to inform himself, and a good number of cases maybe good number of cases may not come to the High Court, may not come to the Supreme Court, may not go to the trial court itself. I have a feeling that this is going to reduce the workload and workload on our judicial officers. I will come back to the slide again. Thank you for asking intermittent question that indicates that things are reaching to you. The fourth stakeholder is the prison officials. And in BNSS, the role of prison officials for the purpose of bail has become very important. Can anyone tell me why? Can anyone tell me why? That prison officials' role in case of bail has become more important, far more important in BNSS. It was not the case in CRPC. Can anyone tell me why, please? आपको सवाल समझ में आ गया होगा. हमारा सवाल यह है कि प्रिजन ऑफिशियल्स का बेल से क्या मतलब है. लेकिन भारतीय नागरिक सुरक्षा संहिता 2023 जो सीआरपीसी को रिप्लेस की है, उसमें बेल को लेकर प्रिजन ऑफिशियल्स की भूमिका बहुत ही इंपॉर्टेंट हो गई है. ऐसा क्या हुआ है, कोई बताए मुझे आप. भारतीय नागरिक सुरक्षा संहिता में ऐसा क्या परिवर्तन हुआ है कि प्रिजन ऑफिशियल्स की भूमिका बहुत ज्यादा बढ़ गई है. एनीवन कैन ट्राई. गलत होने पे कोई दिक्कत नहीं है. गलत तो होता ही है. सुप्रीम कोर्ट भी गलती करती है, हम भी गलती करते हैं, फैकल्टी मेंबर्स भी गलती करते हैं, रिसोर्स पर्सन भी गलती करते हैं. गलती कर करके तो दुनिया आज यहां तक पहुंच गई है. वी ऑल कमिट मिस्टेक्स एंड फॉल्ट्स एंड ब्लंडर्स एंड वी लर्न फ्रॉम आवर मिस्टेक्स, फॉल्ट्स एंड ब्लंडर्स. कैन एनीवन गेस? क्विक. वी हैव नॉट मीन, आई हैव, आई थिंक, Nafisi, I have 15 minutes more or more you are giving. Please unmute, sir.
It is up to you, sir.
Oh my God, you are
You are
giving
the
me.
full freedom. You are the master of the show now.
Oh, क्या बात है, क्या बात है. I don't know whether the house is liking or not. Would they tolerate for half an hour more? I don't know
Yes. No.
whether they are going to
Definitely,
tolerate.
please continue. The questions may be invited here, even in between. Intermittently, everybody is participating, so that is an integrated approach. Fine.
नहीं मिला किसी को, चलिए मैं आपको एक गेस देता हूँ.
That's
हाँ,
may I say?
yes,
Yes.
please.
Actually, in re-policy decision of grant of bail, Honorable Supreme Court of India has specifically issued some guidelines, and some of them has been incorporated in the Bharatiya Nagarik Suraksha Samhita 2023, where even on today, as per that guidelines, we are supplying copy of the bail order through mail to the superintendent of the concerned jail where the accused has been detained, so that same will be intimated to the concerned accused
Okay.
regarding grant of bail. Now, as in the new act under section 479,
Yes.
subsection 3, duty has been entrusted upon the superintendent of the jail, where the accused person is detained on completion of 1 hour or 1/3 of the period mentioned in subsection 1, as
Yes,
the case
yes.
may be.
You got it.
The court will take an application in writing to the court to proceed under section 1 for the release of such person on bail.
Wow, very good. Excellent. You must clap for Bibaswant Gautam ji. Very good. So it is section 479 BNSS. It was 436 capital A in CRPC. 479 you can open. It makes some changes. Earlier the provision was that in case of bail, in case a person is under trial and he has spent half of the maximum punishment, he can be released. Now the things have changed. Even
Sir,
one
sorry to
third.
interrupt, sir. Exceptions were there that in case otherwise offense punishable with death or imprisoned for life.
Yes, that exception is always there. That is correct. Now the change has been made that one half has been replaced by one third. That if a person is a first time offender and he has spent one third of the punishment, not half of the punishment, half of the time, one third of the time he has spent in jail under trial prisoner, he has to be released on bail. Otherwise, if he does not come in otherwise, we have around 5 lakh under trial prisoners, and that is a gross violation of human right. I would say that is a blot on Indian democracy, that we have 5 lakh under trial prisoners. What is the government doing? What is judiciary doing? What are intellectuals doing? What for these all things are? What for this constitution is? When we have 5 lakh under trial prisoners languishing in jail. So it is good that through this amendment, new amendment, one half have been reduced to one third. Thanks God. Government and the parliament has become little more sensible. तो अगर आपका पनिशमेंट है मान लीजिए 10 साल तक और आपने 3-3.5 साल की सजा आपको मिल गई है, यू कैन नाउ कम अंडर दिस प्रोविजन, या आपकी सजा 7 साल तक है तो यू कैन कम अंडर दिस प्रोविजन कि भैया हमको रिलीज करो, मेरा 1/3 हो गया है. बट व्हाट इज मोर इंपॉर्टेंट इज क्लॉज 3. क्लॉज 3 ये कहता है कि सुपरिंटेंडेंट ऑफ जेल इज गिवन दिस रिस्पॉन्सिबिलिटी make an application writing to the court. It is not the responsibility of the lawyer or the accused person. Another golden change that has been made, revolutionary change that has been made, is that the superintendent of jail has been made responsible for it. नहीं तो वो गरीब लोग, लाचार लोग हैं, वो उनमें से कई लोगों को पता भी नहीं है, उनको फ्री लीगल एड भी मिलती है तो लॉयर उनके पास कभी जाते नहीं है. लॉयर जाएंगे कैसे? उनको मुश्किल से 500-1000 रुपये हम देते हैं. प्रिजन की दुनिया एक अलग दुनिया है. हम अपने एसी कमरों में आराम से बैठे रहते हैं, गरीब आदमी वहाँ परेशान हो रहा है. उनमें से हो सकता है कि उसने अपराध किया हो सकता है उसने अपराध किया हो, इसमें कोई डाउट नहीं है, पर इसका यह मतलब नहीं है आप जल्दी से सजा दो उसे, पर बिना सजा दिए उसको जेल में रखते हैं. सो ए रिवोल्यूशनरी प्रोविजन हैज बीन डन बाय द पार्लियामेंट एंड पार्लियामेंट मस्ट बी अप्रिशिएटेड लाइक एनीथिंग. बहुत बढ़िया प्रोविजन उन्होंने किया है. बट द मूट पॉइंट इज नाउ bail has to route through prison official. It is the responsibility of the prison official. उनकी जिम्मेदारी बनती है. Now how come AI comes in picture? And AI comes in picture इस प्रकार से कि जो प्रिजन का डाटा है वो उनके पास ऑलरेडी है. उनके पास पता है कि किस डेट को कौन से अपराध में आदमी पकड़ा गया, इन विच ऑफेंस द पर्सन हैज बीन एप्रीहेंडेड एंड अरेस्टेड. क्या ऑफेंस है, किस डेट से वो है, कितने समय वो बाहर रहा है, कितने समय अंदर रहा है. ही कैन प्लेस ऑन डाटा. वो ये नहीं कह सकता अरे साहब ये तो इतना बड़ा डाटा है, हमें तो अब 1 साल लगेगा, हमें तो स्टाफ चाहिए, हमारे पास पैसे नहीं है. नो, देयर इज नो नीड. ए trained chat GPT can do it easily. So I think this, for the prison officials, for the purpose of prison, the government should take additional care and maybe court should also, क्योंकि सरकारें तो अपने दूसरे कामों में लगी होती हैं, उनको नेक्स्ट इलेक्शन की केवल चिंता रहती है, उनको नेक्स्ट जनरेशन की चिंता नहीं है. और प्रिजन वालों को कौन पूछता है? जिनको ना वोट देने का अधिकार है, जिनके पास लोग आसानी से पहुंच नहीं सकते. तो मुझे लग रहा है कोर्ट्स को इसका कॉग्निजेंस लेना चाहिए कि मेक स्पेशल ऐप फॉर देम, मेक स्पेशल AI जनरेटेड ऐप फॉर देम. वो खुद समझ सकें, खुद जान जाएं, ऑटोमेटिक नोटिफिकेशन आ जाए कि आपको जो है 3 साल, आपकी ये साल जो है 1/3 प्रोविजन, आपका 1/3 इस डेट को पूरा हो रहा है. उसके परिवार वालों को खुद ही नोटिफिकेशन चला जाए. ऐसी कोई व्यवस्था हमें करनी होगी. ये भी एक रिसर्च का बड़ा प्रोजेक्ट हो सकता है. जो एकेडमिशियन हमारे साथ हैं वो इस साथ, जो रिसर्च स्कॉलर है साथ में हैं, वो इस दिशा में रिसर्च करने के लिए सोच सकते हैं. Now let us come to the foreign experiences, some foreign experiences. When I say that let us come to the foreign experiences, that again reminds me when I used to be in the last session of refresher courses and orientation courses and training program. जब लास्ट में हम होते थे तो हमारे दिमाग में जो पहला क्वेश्चन आता था वो होता था ये जो लास्ट वाला आदमी आया है वो कितने देर तक बोलेगा. दिस वॉज फर्स्ट क्वेश्चन दैट आई ऑलवेज थॉट ऑफ. और सेकंड, जब हम कहते थे कि अब ख़त्म होने वाला है तो फिर एक अच्छा सा गाना याद आता था जिसको कहते हैं दुख भरे दिन बीते रे भैया सुख भरे दिन आयो रे. सो आई विल नॉट इंक्रीज दिस दुख भरे दिन टू यू and try to finish in the time, within time. Let us see the USA experiences and UK experiences. One of my students, Kshitij, who is a LLM and also an engineer, MTech from outside, he has suggested me these things. I am grateful to him. Like many of my PhD scholars, Avinash Paswan, PhD scholar ILI, Apoorva Verma, PhD scholar ILI, Siddarth Srivastava, PhD scholar ILI, all three under me, and two, that is Kshitij, who passed from ILI, LLM, and another Deepak. He is practicing and he is also a technocrat and a lawyer. Kshitij has suggested me these things, that USA, New Jersey adopted the public safety assessment tool. Public safety assessment tool, and the tool worked. So in this tool, yes, this tool was made in 2017 in USA, and the main objective was pre-trial release system, and they have made certain grounds to suggest the court whether pre-trial is possible or not, and New Jersey reported 20% decrease in pre-trial jail without an increase in crime rate. So there is a success story, and I think this has to be studied properly, thoroughly. In UK, United Kingdom Bail Act of 1976 is there. In Until case, Justice Call also suggested India should have a bail act, but you know new law has come, but no bail act is coming. So in UK, offender assessment system, OASYS, there is a system, and another is risk of reoffending, ROR, and this system has been used to determine bail conditions, and they have reduced pre-trial detention rates and ensured that bail decisions are more consistent and transparent. In 2018, Ministry of Justice report in UK, they found that introduction of risk assessment tools in England and Wales, they have reduced this custody and pre-trial detention. They have reduced at least 10% decrease in pre-trial detention between 10 to 2017. Now these are the success stories, but as I know, there are challenges also, and the first challenge is the challenge of bias, other is challenge of transparency. किस तरह के रिकॉर्ड हम डालते हैं उसमें, ये बड़ा इंपॉर्टेंट है. Therefore I told in the beginning, we have to follow the rule of P6. किस तरह के जजमेंट आपने डाले हैं, सारे जजमेंट आए कि नहीं आए, सारे लॉज आए कि नहीं आए, ये बहुत जरूरी है. And therefore the government and the court should take control of this, and they are taking control of it. What is the idea of bias? The idea of bias is that it was found in the research work that in USA, when the chat GPT or similar tool was used, and it was asked that in these cases, what are the chances that this person or this accused will jump bail, will be we will tamper with the witnesses. It was found that the chat GPT or the AI tool used in USA has suggested the number that shows that blacks are more likely to jump the bail than white. Why this happened? The researchers say this happened because the data that was fed is biased. Data is not important. So this is a very significant issue in our case. Is there any possibility that if we make a tool which can make assessment, in cases of bail we make risk assessment, whether he will go and tamper with the witness, the trial test, the triple test. So is there a possibility that people from vulnerable group, people from minority communities, people from SC/ST communities, people who are from weaker section of the society, is the chat GPT going to suggest that they are going to jump the bail more than other people? If this is so, is it because of bias or is it a fact? Or it is likely to be a fact? So we have to be alert. We have to be very much alert. In some of the tools, the algorithm that is used is postcode also. That what is the age of the person, what is the gender of the person. When we are going to decide through chat GPT or AI whether the person should be granted bail or not, will he follow the triple test or not, so we write what is the name, what is the gender, what is the postcode also. To name gender is understandable. What is the postcode? Postcode is something like pin code. So the pin code is written and pin code mentions a particular area of Delhi or Ghaziabad. So that particular area is a type of profiling. So it was argued that no, postcode is not the correct rules of algorithm. That should be removed. So these are some of the biases that we have to address. But let us understand how this bias can be addressed. These all bias can be addressed by regular audit of algorithms. Regular audit of algorithm. But let us understand that there is a difference between bias in USA and bias in India. There are individual bias that probably is very difficult to address overnight. Individual bias regarding religion, regarding caste, regarding area, regarding gender, and that will take more time. But institutional bias can be removed by making laws. So far as institutional bias is concerned, India and USA are two different things. Let us understand. How? Let us go in the history. The USA Constitution was ready in 1787. It was ready in 1787. 1787. It was signed in 1789. In 1787, it was ready. It was not signed. 2 years later, it was signed. It was not enforced. You know the reason? In 1787, it was not signed. It took 2 years to enforce. Why? Because all states were not ready. Why states were not ready? Because the Constitution of USA did not contain fundamental right provision at all. A constitution that does not contain a provision of fundamental right, what for the constitution is made? Why they did not incorporate fundamental right? Because they were not ready to accept the principle of equality. Black and white will sit together. Black and white will eat together. Black and white will go in the same coach. No, this is very dangerous. How can a master and slave could sit together? Therefore, they did not incorporate the doctrine of equality. 1791, first 10 amendments were passed in USA. I think we all should be happy. चलो भाई अच्छा हुआ, मौलिक अधिकार तो मिल गए. You will be surprised to know right to equality was not made a part of those 10 amendments. Why? The same institutional bias. The same institutional bias of the government, various governments and the stakeholders, that नहीं white और black एक साथ कैसे रहेंगे, कैसे काम करेंगे, slaves और master एक साथ कैसे काम करेंगे. It took many years. Then in 1865, through 13th Amendment, slavery was abolished. See, there was a constitution and there were fundamental rights which were made in 1791, but it took around 75 years to make equality a fundamental right in USA. Why? Because institutional discrimination was there, institutional bias was there. Not only this, the Supreme Court decided in Plessy versus Ferguson in 1896, after 103 years of fundamental right incorporation. क्या हुआ उसमें? So because slavery was declared unconstitutional, and in 1868 14th Amendment came in and right to equality was also accepted. So a case went to the Supreme Court. In that case, what happened? There were two types of coaches in train. One coach was for black, other coach was for white. Blacks could not travel in white's coach, despite there was a right to equality provision incorporated in 1865. So the matter went to the Supreme Court. Supreme Court asked, ये बताइए क्या टिकट का प्राइस एक है कि अलग अलग है? टिकट का प्राइस तो एक है, ब्लैक को भी वही पैसा देना होता है जो व्हाइट को देना होता है. The money that is spent on the fare of coach by black and white is same. बोले okay. Is the furniture different? The coach, जिस कोच में व्हाइट ट्रेवल करते हैं, जिस कोच में ब्लैक ट्रेवल करते हैं, वो फर्नीचर सेम है कि अलग अलग है? बोले तो फर्नीचर तो एक ही है. बोलो अदर फैसिलिटीज भी एक है, विंडोज भी एक है. Then the Supreme Court said, then what is the problem? Why do you want to go inside the coach of the whites when you are being given this facility in your own coach? This was the understanding of the Supreme Court of USA. Institutional bias was there. USA Supreme Court has an institutional bias. Initially the parliament had the institutional bias, the executive had the institutional bias, and the Supreme Court had the institutional bias. Ultimately in 1954, dear friend, when we passed our constitution, we became republic. After our constitution was passed in 1950, we made it very clear, no discrimination. Maybe in practice there is discrimination. In the institution, no discrimination, no bias. Then in 1954, the Supreme Court of USA declared that no, there cannot be different coaches. Why this is important for us? Why this is important for us? This is important for us because the bias argument is very much correct in USA, but the bias argument is not equally correct for India. It does not hold good equally with the same force as it is in case of USA. So we should be worried, but we should not be worried like the USA people or USA experts are worried for the application of ChatGPT and AI. Our system is different. We have made 1950, we have not only brought in equality, but also made it punishable. Just concluding, sir. Made it punishable that if you say someone with if you discriminate against maybe untouchable, it is punishable under initially Civil Rights Act and then SC/ST Act. There is no such provision. You can indeed tell a black at nigger there and no law comes in picture. No criminal law. That is the difference between freedom of speech in that place and our place. That if you say something, it can become criminal. So our framers of the constitution, in the great leadership Bharat Ratna Dr. Ambedkar Sahab, has given up a great constitution to reduce the institutional bias. Say therefore, my dear friend, we should not be very much worried for this bias. Yes sir, Nafis sir.
So now quickly we can take one or two questions from the honorable member of this august audience. So please,
Yes, please. If there are questions, please ask questions.
even comments, observations. may
Yes,
also be-
comments, observations, agreement and disagreement also.
Sir, most respectfully, I would like to disagree on 2 points, sir. The first point is that that actually ChatGPT being very helpful for judicial officers. Sir, I would just like to, sir, if you can actually, you have the GPT on, sir. If you can actually show me the screen, sir, I would like to ask a few questions to the ChatGPT, sir.
Even you can also share your own experience. What exactly you
Sir, I will
have.
just at least second. So, sir, I will just say, sir, if you actually type in ChatGPT is section 324, non-bailable or bailable in nature. So you can just type in section 324 IPC, non-bailable or not.
Section
324 IPC,
324 IPC.
non-bailable or not. So while ChatGPT answers the question, I will tell you that ChatGPT will actually answer it that it's non-bailable in nature. The second question, when you put to it, section 324 IPC, bailable in nature, it will actually say sorry for the inconvenience and confusion caused earlier. Section 324 is bailable in nature. You can again type in section 324 non-bailable, then it will again say sorry for the confusion. Section 324 of the IPC is non-bailable in nature.
Good. Yes. So, sir, what do you want to conclude?
Sir, just want to conclude that actually, sir, law is a very specific science, sir. And ChatGPT is a populist view, sir. It gives out popular opinions rather than the correct answers. So, sir, this actually comes to my second disagreement is that, sir, why bias will be, sir, actually will be more in India. Like we have to be concerned about the bias. If you go to the magazines like all AIR, SEC Online, there is actually a magazine called Acquittal in India. But you will not find a magazine called Conviction in India. So what the ChatGPT will do is that it will actually push the machine towards acquittal rather than actually giving out correct decisions. Because of the information that has been fed to it inadvertently or unintentionally is more towards acquittal rather than conviction. So, sir, the biasness will be in India, it will be actually towards acquittal rather than conviction. I'm not saying that it should be done actually as per law, but now the ChatGPT, when it will be taken help of, then it will actually push convictions towards, it will actually, like, let's say that I have actually decided that I will convict. When I put all those questions to the ChatGPT, it will actually try to modify mine towards acquittal. So I really do not think that at this particular stage, like ChatGPT is growing, I think that law is a specific science. It has to be, the parameters and the algorithms have to be very specific so that it gives out correct answers rather than actually depending on it whether to decide bail or not, whether to decide case is right or not. So you can actually check the section 324, sir. I will think that I have made my point, sir.
Yes, you have made your point.
Yes, sir.
And if I can address it further,
Yes,
that
sir.
this is not the only answer. I can convey you many answers. For example, if I write like who are the faculty members of South Asian University, you will find a faculty of law. You will find the Delhi University teachers are also shown as South Asian faculty members. So the whole point is that ChatGPT is not something 2 plus 2 equal to 4. This is one. ChatGPT is to some extent helpful to us. It is just an helping thing, and therefore I will just pass this and conclude this with the last PPT. Probably that will help and maybe decide, maybe helpful to all of us. Sorry. Yes. So what is the way ahead for us? And my first conclusion answers your question. Adaptability but not dependence. Neither me nor anyone says that we have to be dependent. We have to adapt, and when we adapt as per our own requirements. So therefore, while ChatGPT can answer many things wrong, ChatGPT can address many things right also. So let us not be dependent, but that does not, I think, that does not say that ChatGPT cannot be used. It should be used. It can be used. It has to be. Second, judges and other stakeholders are irreplaceable. I don't think they can be replaced. No, there is no, and neither it can be nor they should be. So it is a matter. It is not only possible, or it is also a matter of social justice. Third is, there are chances that innovation may be arrested, may be reduced. Why? Because ChatGPT and AI is only going to work on the historical things, what is already there. And therefore, as the words used are value lock-in, so new things may not come, so we should be alert that new law must evolve, and this is the human brain can work. Bail, fair trial is a matter of fundamental right. Therefore, there has to be additional alertness. As you rightly said, that it may lead to acquittal, more acquittal and less on conviction. So we have to be more and more, we have to be alert. That is a matter of fundamental right. Bail is a matter of fundamental right. So additional alertness should be there when we use this thing. This is a transformative opportunity, there is no doubt. And we should be ready for the transformation the way we made ourselves ready for the cell phone. There is hardly any person who will say that no, I am not going to use cell phone. There would be some great people, I don't know. But this is a transformative opportunity, and we should make ourselves prepared for that. The way you have rightly pointed out 324, I think if ChatGPT is continuously conveyed that, see, your answer is wrong because 324 is not what you are telling, a time will come, because it is a machine learning, it is improving itself. After maybe 1 month, you will find wherever you will put, whether it is valuable or non-valuable, it will give the correct answer. This is how it improves itself, and that's why it is the artificial intelligence. Next is, it will reduce backlog significantly, and many people feel it will. It will also reduce pressure on the judges, public prosecutor, and maybe police officers also. And a national risk assessment tool for bail purpose is not favorable. There cannot be one tool that can assess the risk pan-India, because it is local. The conditions are local. So we have to understand. With this, I conclude my discussion, but I am open to all questions. Again, thank you.
Yeah, I think Honorable Judge Ganthia ji has raised his hand.
Yes, please.
Yeah, please.
Sir, I have two suggestions
Yes.
and one question. So should I begin with the suggestions and the questions?
You
Sure.
sir, you begin with your suggestion and then you ask question.
I have two suggestions. One is that AI is to assist the judge
Yes.
in nutshell, but not to substitute the judge. This is one most important suggestion I have. And second one is, since there is no policy or law to control the improvement or the collection of information and giving information by the AI, there should be a mechanism to control it. Otherwise, time will come, it will create a disturbance in the society by giving two dichotomous two judgments, two decisions, which may not be acceptable by the people or the legal fraternity. And my question is that whether AI can fruitfully be used in chemical examination, because most of the cases are pending for chemical examinations, and there is a very the staff strength is very weak, or there is a scanty deficit. So if AI is used in the chemical examination, it can to some extent reduce the burden on the SFS. Can it be so?
Thank you. So,
So I think not only that it is. So I go to your suggestion and think the bold letters explain that your suggestions and my suggestions match each other. That there is no dependence and match with many person, I think. and it is judges cannot be cannot be replaced and advocates cannot be replaced. So far as the control mechanism is concerned, certainly we have to be concerned that the key should be with us. Just I will take you back to the robot age. When in 19s we came to know the robot is coming, we were told that robot will come and robot will do anything and everything and robot will control us. And robot did not come in 2022. It did not come in 2012. It did not come in 2002. It came way back in 1992. We are talking about robots. But robots are not controlling us. So similarly, I don't think AI is going to control us. But we must be alert, there is no doubt. There is no doubt. And if required, we may need to make laws. We need to make laws that how our privacy should be secured. Because the documents are there, our data are there, our privacy should be secured. This is one. Now, so far as CFSL suggestion is concerned, I think this is a very good suggestion. And I'm sure they are using it. If not they are using it, they must be similarly worried the way I and you and South Asian University is worried. I have no first-hand experience whether they have started or not, but you have given me a pointers. I often go at least once in a month to National Forensic Science University to interact with the members of Forensic Science Laboratory, and I will definitely ask them whether they have started doing it or not, and if they have started doing, how are they doing it. But one thing is very clear, that if there are many reports, so for example a case which has maybe multiple witnesses, multiple cyber reports, there will be hundreds of pages. AI can certainly identify useful pages, can certainly make it useful for the courts and the officers, and again the officers can doubly sure that their findings are correct or not. Thank you again. If there is any supplementary, I am open to the supplementary.
Yeah, thank you very much. Now, before I request my research coordinator to propose a vote of, let me point out, it is in continuation of the question that has been posed as well as the suggestion. There is a book which has been written by Professor Simon Chesterman of National University of Singapore, and that has been published recently by the Cambridge University Press, and the title of the book is We the Robots. So my recommendation would be, please, whenever we find any opportunity or entire audience, find a chance, we must study this particular book. It is not a very comprehensive one, but it is an eye-opener on this particular discussion which we were having today. Having said that, now I would like to request Ms. Sagarika Yadav to propose a vote of thanks to the audience, including the resource persons.
Yes, sir. Thank you so much, sir. Thank you so much, sir. That was truly an insightful session. I'm sure our participants will have much to deliberate upon after this session. Also, thank you to all the participants for your continued support and enthusiasm. We truly appreciate your cooperation. With this, we come to the end of this session. See you all tomorrow at 4 o'clock for the next session.
Thank you very much. Thanks.
Thank you, sir. Thanks a lot. Thank you, honorable judges, my distinguished participants, my colleagues, my learned colleagues, and other, ladies and gentlemen. Thank you. Thanks a lot for everything.
So I request that if you are interested in more intellectual discussion, you can approach me on this YouTube channel, and it contains, but there is no quick type of thing. The most of the discussions are more than maybe 1 hour. So
I would like to request you, sir, please share your PPT presentation of today for the entire audience.
Yes, and one can approach me on this phone number also. I will share the presentation. Thank you, Nafis bhai. Thank you, everyone.
Thank you, sir. Thanks a lot.
Ahmad sir, tomorrow's topic?
Tomorrow's topic would be predictive policing. That would be delivered by Professor Dr. K. Jayashankar. So, remarkable one. He is an expert. He has already contributed a lot of literature in this regard. So, we are going to have a very wonderful discussion tomorrow. Thank you very
Thank
much.
you, sir. Thank you, sir. Sir. Deep, sir, namaskar, sir.
नमस्कार सभी को, नमस्कार सभी को, नमस्कार.
Thank you, sir.
Thank you, sir.
Yeah. I take a leave to leave. Thank you. Thanks a lot.